Resurgent India Knowledge Series presents Virtual Session on the Digital Personal Data Protection Act, 2023 Implication and Impact. Ms. Sandhya Tanwar, Resurgent India Limited. Sandhya Tanwar is an advocate, member of the Institute of Company Secretaries of India and postgraduate diploma holder in business administration in the field of finance. She has more than 15 years of experience and was earlier associated with PricewaterhouseCoopers Private Limited, PwC, and SBI Merchant Bankers Limited. Mr. Sumit Kochar, Partner Dolce Vita Advisors. Sumit Kochar is a corporate lawyer and succession and estate planning coach with primary areas of expertise include estate and succession planning, advising family offices and OHNIs in business and estate planning, multifamily office advisory, specializing in planning of intergenerational wealth planning and governance, financial and tax strategies for assets protection, wealth transfer and tax-related issues, mergers and acquisitions, covering structuring, capital markets, corporate, foreign exchange and contract law advice and documentation. Mr. Shivam Geda, Principal Associate Dolce Vita Advisors. Shivam is a dynamic and passionate professional with progressive experience in advising on corporate and commercial laws, mergers and acquisitions, business and asset transfers, fund formation and structuring, estate planning, corporate tax advisory, exchange controls, and cross-border advisory. Mr. Tabrez Malawat, Partner, The Guild Advocates, and Associate Counsel. Tabrez holds the distinction of having appeared in and steered a broad range of high-profile cases in different courts such as Supreme Court of India, High Courts and Regulatory Courts, Tribunals. He is a penal lawyer of Government of India in Supreme Court and also empaneled with State Bank of India. He has experience of advising and representing big multinational companies, public sector undertakings, financial institutions and HNI amongst others. Mr. Ashit Garg, General Counsel and Company Secretary Rambal India. Ashit is currently working with Rambal India as General Counsel and CS. He has approximately 15 years of work experience with chemical manufacturing, automobile, insurance and engineering consultancy industries. About his professional background, he's Company Secretary, ICSI, Chartered Secretary, CGI UK and Ireland, and Certified Expert Practitioner in EU GDPR.
Good evening, everyone. We welcome you on today's virtual session, wherein we will be discussing implications and impact of the Digital Personal Data Protection Act 2023. In an era dominated by digital advancements, the management and protection of personal data have become paramount. The introduction of DPDP Act by the Parliament of India marks a significant milestone in safeguarding individuals' digital personal data while enabling its lawful processing. This session, the objective of this session is to shed light on the key facets of the Act and its far-reaching consequences. And for this, we have brought together industrial experts, legal minds, and thought leaders to discuss the nuances of the DPDP Act with us. So I welcome all the speakers of today for this session. So to discuss the implications and impact of DPDP Act, we have Mr. Sumit Kochar, Partner Dolce Vita Advisors. We have Mr. Shivam Geda, Principal Associate Dolce Vita Advisors. We have Mr. Tabrez Malawat, Partner The Guild Advocates and Associate Counsel. And we also have Mr. Ashit Garg, General Counsel and Company Secretary Rambal India. We welcome you all. Thank you so much for coming live with us.
Thank you.
Thank you, Sandhya.
Thank you for the introduction.
Thank you. So we would start this session to discuss the right to privacy and data protection. And for that, I would like to invite Ashit to discuss about the case of Justice K.S. Puttaswamy, wherein it was established that privacy is a constitutionally protected right. Can you please give us a detailed explanation on the Act's role in upholding the right to privacy as a fundamental right? And please discuss this case about us. Like, what is this case all about? We would really like to know about this, Mr. Ashit.
Sure. Thanks, Sangha, for having me. First of all, I like to mention that India is a signatory to the Universal Declaration of Human Rights and the International Covenant of Civil and Political Rights, and both of which acknowledge the right to privacy. So talking about this case, just you mentioned, particularly in year 2017, the Puttaswamy judgment has established that privacy is a constitutional protected right, which emerges from Article 21 of Indian Constitution. So as an element of privacy can be read into the rights of freedom and dignity, which are being guaranteed under Part 3 of the Indian Constitution. So this about this case, court further reasoned that privacy is not an absolute right like other fundamental freedom, and under Part 3, Honorable Justice Chanchud written in his judgment that law which encroaches upon privacy will have to withstand the touchstone of permissible restriction on fundamental rights. Thus, in the context of Article 21, an invasion of privacy must be fulfilled on the basis of a law which stipulates procedure which is fair, just, and reasonable. So you basically
We can't hear you, Ashit.
the invasion of life of fundamental right in. I'm sorry, can you hear me?
Yes, we can hear you.
Yeah, so this present judgment has reshaped the ambit of fundamental right in Indian constitutional history. The Indian judiciary has acted as a true guardian of the liberty. It has given the Indian government an opportunity to rethink its data protection mechanism, both in light of individual privacy and the interest of the state. So after this judgment, an expert committee was constituted by the Ministry of Electronic and Information Technology. And the first major development was in December 21 when the bill was released. However, it was withdrawn in the parliament last year in August. But further in November 2022, the bill was released for public consultation.
Right.
The submission made under this consultation process were not made public. However, there was an ITI application which requested to publicly release the submission, however, that was denied. So finally, Ministry introduced the latest version of the Digital Personal Data Protection Bill in the Lok Sabha on 3rd of August this year. And later, the bill got passed on 11th of August on 23, when the President gave her assent. So this is the overall progress on a data privacy law in our nation as of now.
Right. Thank you so much, Ashit. So let's discuss about the role of data fiduciaries and something about data principles which have been mentioned in the Act. Data fiduciary is any person who alone or in conjunction with other persons determines the purpose and needs of processing of personal data. So this is a definition which has been provided under the DPDP Act. I would like to ask Tabrez here. Can you please explain us what are the key obligations of a data fiduciary?
Thank you, Sandhya. First of all, I must express the gratitude to the Resurgent for organizing a webinar on the issue, which is of utmost importance. To start with, Sandhya, we have to understand this law that has come into force now is a law that relates to the new era, new market, new economy. The entire paradigm of the business transaction has been digitalized. Therefore, all data which was prevalent or existing in form of paper has come into a virtual form. Now, in order to understand the entire implications of it, there are two important constituents of it. One is the data fiduciary, and another one is the data principal. As the name suggests, data fiduciary is the person who in a trust is going to hold data of a data principal, who is the owner of a data. For example, if I am the owner of a data, I have gone with some insurance company or health insurance company that I wish to procure a health insurance from you, and this is my medical history. So I am the data principal giving it to data fiduciary, who is going to process that information. So these are the two important constituents in the entire segment of the Act. Now, what the question that you have posed to me becomes relevant in this background is this, that this data fiduciary is the one who's going to hold this information in a trust. Therefore, it's become very important for it to process the data in a manner that first, it is the data which is required to be processed. For example, what data they've collected is relevant for health insurance, they should process that relevant information only. And while they take my consent, they should take consent in a very specific manner, unambiguous manner. So I'm aware of it. And while taking my consent under the Act, they have to provide the similar easy mechanism to withdraw it also. So that is another important milestone, or the important character of the Act, where it has been simplified the manner in which I can withdraw my consent. Thirdly, there is also additional obligation on the data fiduciary to provide a mechanism, a safeguard to protect the personal data from any potential breach. So under this obligation, if a cyber attack or a security breach takes place, it's an obligation of the data fiduciary to protect it. And in the event of that breach, it also has an obligation to notify me, also the regulatory authorities, such as the board, which has been constituted under the Act, that this breach has happened, and to provide what is the nature of breach that has taken place. In addition to that, they have an obligation to provide a consent manager, which is a point person for a data principal to contact and understand that what are the problems it might have, and to provide a regressive mechanism for it. In addition to that, they also have an obligation similar to that we have under right to information. I have a right to access. I can go ask them what are the information that you have collected and which are the people with whom your information shared. So these are the right to access also being provided to me, and that becomes an obligation of the data fiduciary. So this is the broad spectrum or the contours of the obligation that a data fiduciary has to follow under the Act, and that has been crystallized under Section 8 of the Act.
Yeah, right. Thank you so much, Tabrez, for shedding light on data fiduciary. I think they will have very important role in playing with the information, and whom they should give the data and how to process the data. And like you said, in India, in today's world, in today's era specifically, we never had any law which would protect the personal data. There was our Information Technology Act, but there was no detailed provisions and consequences or penalties with respect to the personal data. And after COVID, we all have been using a lot of social media, professional media, and lot of everything has been digitized, and we have been sharing our personal information with the way you have shared on the health front. We have been sharing a lot of personal data to hospitals and other agencies. So yeah, it becomes really important.
Very important to regulate it. And I'm glad that the Act is finally there to regulate, which is most important to them.
Yeah, right. So like we have been talking about personal data, and this name of the Act has come from personal data, and a lot of we have been discussing on that. So I would like to ask Sumit, how do you think the Act specifies on the grounds for processing personal data, and what is personal data? Like Tabrez shared, when we go to a hospital and we share our medical history, our personal details. So that is personal data. But we would like to know more about how the Act defines this term personal data.
So I'll start by a video or a joke which everyone must have seen, and as you also rightly pointed out, about the medical history. So it's not very far that you'll call Domino's or a Pizza Hut and order, I'm sorry, I'm taking names of brand. So, and there's, you'll order, say, a pizza with cheese or say pepperoni, and the other guy on the other side might say that, boss, you have high cholesterol, so don't eat this, you're not taking your medicines properly. And he'll start advising you whether this is the right choice of cuisine or this is the right choice of pizza for you or not, and you should have more veggies. So this is a pseudo breach of personal information, and this is actually the processing of data. And then that would be the day that you would know that your data is being sold out there in the market and you have fallen for your data has been compromised. And personal data can be anything by which and it is, very fascinating that the act is calling us, those who share our personal data, as data principals. And in relation to children, they are covering the parents also, those who are managing their data. In relation to their, say, Instagram accounts, like children these days have, or a disabled person as well. And the data fiduciaries are being bound, and they will be pulled up with such high penalties and actual cognizable offenses, and with such high penalties and procedures pertaining to putting in place systems with data protection officers, consent managers, and compliance officers, that yes, the only medium you are earning your money from, be it a fintech company or be it a bank or any other company or a startup which thinks or has now realized that data is the king. So the processing of that particular data, which is your personal data, be it your Aadhaar number, which requires masking now, be it your car number, your loan details, your CIBIL, which is another breach when an ad comes and says, check your CIBIL, it has upgraded or downgraded. That is another way of taking your data from you and taking your PAN, and within 15 minutes, a firm or any other DSA will start calling you with a loan application, seeing whether you have taken loans or not, because they have analyzed your data. They have processed your data. That is what the government is coming forth and putting us as data principals in the front line. And why us as lawyers, since Tabriz is using so many words, that we are glad that obviously this is a new era in India of new way of practice. So obviously it will boost the other day I was reading an article that the companies in India and corporates have spent 40,000 crores on legal services in India. So this will obviously boost our industry as well. But besides that fact, this is one way that Indian government is actually, seeing that the data and its processing is very important. And they need to understand, and the act specifically says that processing of data by the fiduciary has to be, as per the act, it has to be for lawful purposes, and it will need consent if it is as in for legitimate purposes. And where the consent is not given, then there are various aspects like giving it for using state subsidies, or where there is a court decree to be passed, or it is for some non-digital forms where it has to be given, or the data where personal data without indicating specific consent is being given. So that also comes under legitimate uses of that particular data. So these are some aspects where personal data processing and its use has been put in the act, and the government, has specifically asked for that these procedures needs to be used, and whether these have been followed will be taken up in the audit, like for the purposes of employment, or those who are entitled to safeguarding employers. All these aspects, it has been listed as part of the legitimate uses of such processing of data where consent is not being given. So these are some of the aspects for personal data which are being put in place or have been put in place in the act to be observed by data fiduciaries. those who are processing personal data of an individual.
Thank you, Sumit. Thank you so much. So Sumit has used one term for all of us, which is data principle. So I would like to read the definition of data principle for our participants. So data principle under the Act has been defined as an individual to whom personal data relates, and where such individual is a child, it includes parents or lawful guardian of such a child, and a person with disability includes her lawful guardian acting on her behalf. So all of us, we individuals are data principles, and this act revolves around data principles, data fiduciaries, and data officers, consent managers who would be taking care of our data. Okay. So Sumit also shared about processing of personal data of children, and nowadays, like he very rightly he shared that on Instagram, every child has an account. Like every child is putting all of the information, where are they going, what are they eating, and everything on social media.
And they are the one most vulnerable to data breaches and data getting compromised of them being part of, sorry to say this, child porn or some things which are not acceptable, all compromisation of their data to be done with a child.
Right.
Sorry, please continue.
Yeah. So on that, I would like to ask Ashik, do you, what are the obligations of data fiduciaries which apply to processing of personal data of children or a person with a disability?
Okay, if I talk about the existing rules, which the SPDI rule, which should be read with IT Act, that does not specifically talk about the children and their data. On the other hand, this new Data Privacy Act adds more responsibility for those who handle data when it comes to children and people with disability. So under this act, data fiduciary who handles the data must get a permission known as a verifiable consent from the parent or the legal guardian before they use any personal data of the children. Children means those who are under the age of 18, and the other thing is the people with disabilities. So as of now, this act does not, specify like how the consent would be taken. So this special type of consent, how it will be obtained, and how the data fiduciary would come to know. I mean, what is the age and of the of the child, or and I mean what type of disability, and whether the person is having a disability or not. So this is still unclear. The further, it is also unclear whether the obligation in relation to processing data of children or person with disability would apply only upon user disclosing their children or have any kind of disability. So as of now, Act does not mention any kind of detail. Further, these rules may also exempt certain classes of data fiduciary or personal data collected for certain purposes from the obligation of age verification or monitoring and tracked advertisement. The central government may also lower the age of the majority for data fiduciary who process personal data of children in a verifiable, safe manner.
Mm-hmm.
So the Act does not clarify what would constitute a manner that is a verifiably safe. As Sumit also mentioned that a lot of, I think it is really, I think we should be mindful. I think when our children are having access to the internet, what are they are looking at the internet. So this act also says that it's not allowed to keep track of what children do online and show them ads based on their activity, and to use children data in a way that could hurt their well-being. So the consent has to be taken from the children who was under the age of 18 and the people with disability. But how that consent would be obtained, which is still not clear, and probably it could be clarified when the rules would be there.
Right.
Yeah.
Thank you, Ashik. I think there are few pointers and few information which is yet to come from the government in the form of rules and regulations, which are awaited right at this stage. But yes, whatever we have to at least adhere to that till the rules and regulations come, right? So we were talking about data principles. We as individuals, we are data principles. So the Act also provides rights and duties of data principle. And I would like to ask Shivam here, what are those rights of data principles? And how this Act has given clarity on the rights and duties of data principles.
Yeah, so actually this as clarified earlier by all the other speakers that this act is about the digitized data only and does not cover the physical papers as submitted. So whenever a data principal is the person from whom the data originates and it is processed by the data fiduciary. So whenever the data is passed from data principal to data fiduciary, it should be specified. It should be for the specified purpose only, as mentioned by Mr. Tabrez and Mr. Sumit. So Act also clarifies one example. So example is that suppose Mr. A is opening a telemedicine app. Okay. Then he is giving information about his health. And then thereafter, the app also seeks his consent to share his contact list. So what's the purpose of sharing the contact list? For the telemedicine services. Currently, telemedicine apps are taking data with broader terms without defining for what purpose they are taking this data. But now, first pursuant to this introduction of this new act, they will not be able to take the data for any other purposes except for the telemedicine app. If they are taking the data, they cannot process any personal data of the client except whatever is required. So in this regard, data principals have certain rights under the SPDI rules, which are currently existing and which are yet to replaced by it. Like whenever this act gets effective, this will replace the act. So as per the SPDI rules, they are a right to review the data, right to correct the data, and the right to withdraw consent. So data principal can anytime review or correct the data, request the data fiduciary to review or correct the data, or he can also withdraw his consent. However, to introduce, there are certain other duties and rights on the data principals that now he can, data principal can ask for information about their personal data, including who has it and who they have shared with. Now they have right of grievance redressal. He can file a complaint to data protection officer of the company. And if data protection officer does not solve the complaint, then he can approach data protection board, wherein his complaint will be redressed. Now he has a right to nominate also another person. So in right to nominate, suppose if a person after he dies or after his disability, he has a right to nominate any other person who will resolve his grievance. In future also, he can file a complaint to data protection officer. So his nominee will file. There are certain other rights of right of withdrawal of consent. He can anytime withdraw his consent, subject to like it is not against the law. So these are the new rights which have been given to data principals since they are the actual owner of the data.
Right. Thank you, Shivam. Tabrez, what are the responsibilities of data principals?
So right, with the rights, it also comes responsibilities.
Right.
So there are particularly 4 or 5 major responsibilities that the data principal has under the Act. One is that he should not impersonate himself to be another person. So that is something he has to avoid under the Act. Second, he has to provide accurate information. He should not provide inaccurate information to the data fiduciary. Third is that he also has a duty not to suppress the information. Fourthly, he also need to provide not to file a frivolous or a false complaint before a board or a consent manager. So these are the primarily 4 obligations or responsibilities rather that a data principal has to follow under the Act.
Okay. Legitimate use is asserted when the processing of data is deemed necessary, and that necessity outweighs any risk to the data subject. Sumit, do you think the Act deal with the consent of data principals, and what are the legitimate uses for processing of personal data under the Act?
Yes, so this aspect the Act has very well covered in a manner that they have also covered situations wherein before the date of commencement of this Act, wherein, say, the data fiduciary is under an obligation to, reasonably and in obviously a practicable fashion, give to the data principal a notice as when how his or her data has been processed and for which purpose. And if your rights you feel have been compromised, how you can make a complaint to the board, and the manner in which that complaint will also be processed. And the data fiduciary, may continue to process that particular data or personal data, confidential data, be it any other aspect that a data principal has shared, till the time that specific and particular consent has been withdrawn. It can be either with an e-commerce website, your bank, or a fintech, or where you have taken a loan from, or any other website where you have shared your confidential or personal information. It can either be your any other day-to-day usage websites that you order food from, and where you have put in your any type of personal information. So by this logic, this will obviously, the Act has thought through in a manner that they will protect the data principal to as much as possible, and to the situation, making it not easy, obviously, for the data fiduciaries, but they will ensure that data principal can, as in, is at liberty to withdraw the consent if they learn that there has been compromisation of the data which has been shared with the data fiduciary at any given point in time. Because obviously the data fiduciary is under an obligation to report for any breaches. So this is a very welcome aspect that the government has thought through and put in specifically in the Act. And obviously it will require some work to be put in by the data fiduciaries, and putting ahead as in the personal data, which can be only now used with the agreement of such person. But obviously it is yet to test waters as to how this will be made operational and how it will be made, as the Act also uses the word practicable in the relevant section. So unless it is proven, which obviously can be used as a loophole for legitimate users that you ask. Now, legitimate users are wherein the data subject is willingly, furnishing personal data to the fiduciary for explicit defined objects, and refrains obviously from communicating non-consent to the fiduciary regarding the utilization of the personal data for that said purpose. There can be other aspects also with respect to situations wherein, state or any affiliates entities provides or issues subsidies, benefits, like be it as small as any benefit that a particular class or person takes, for which the data is being provided, and it certifies, licenses, or permits a particular, or to the as in wherein data principal is giving that particular data, and allowances are being given. So these are some situations, and say court is in compliance with the judgments of a particular court, and addressing medical emergencies where fiduciaries are not in a situation to take consents or comply with consents. Now, these are in conjunction with Disaster Management Act also. So they have put in place measures to make it in conjunction and aligning it with the other acts as well. But obviously it is yet to test waters, and it will be assessed how they'll be able to make it operational. But yes, the data principle is being given certain degree of autonomy to determine the purpose for which the data is being processed, used, and processed by various means. Now, process includes the erasing of that particular data which is there, for which earlier consent has been given, and now the consent is being withdrawn. So that also is part of the processing, and the fiduciary is required to give notice and comply with the consent requirements as well. So yes, Act has to some extent dealt with all these aspects, but again, it will be very interesting to witness how this will be made operational.
Right. Thank you, Sumit. So consent to data principle is very important, and how it would be given, what content would be shared, that is very important. But the person who would be taking care of that consent for for processing or for withdrawal, that person's role become very important, and these are the consent managers. So I would like to ask Shivam, who is a consent manager?
Actually, consent managers are a new concept under this act. This was not existing previously. So now it has to be registered with Data Protection Board. So once they are registered, they can act as a single point of contact for the data principals to manage their consent, to review their consent, to modify their consent. They can like communicate with the data fiduciary through consent manager. They can withdraw, they can review, they can accept any consent through consent manager only. So consent manager is required to have a accessible, transparent, and interoperable platform wherein data principal can communicate with the data fiduciary smoothly. So this is the new concept for the consent manager.
Okay. And what is the duration and the amount of personal data that can be held?
I saw one query also. This was asked in the query box. So actually, as I explained earlier, the data fiduciary can store the data only for the specified purpose. Once the specified purpose is completed, he has to delete the data, except certain exceptions are there under the act, wherein, as Sumit has explained about the exceptions, there are certain cases wherein this can be made exemption. So once the specified purpose has been solved, then data fiduciary has to delete all the data, or whenever the data principal withdraw his consent, the data fiduciary has to erase the data, or whichever is earlier, as the specified purpose is solved, or whenever he withdraws the consent, whichever is earlier, he has to erase the data accordingly.
Okay. The Act mandates data controllers and processors to adopt adequate security measures to secure personal data. Ashit, how do you think businesses can comply with the Act?
Yeah, so I think business has to, first of all, there are various ways how business can comply with this act. First of all, they should, like, for example, like if we are dealing with any, online job portal, in case we are looking for a job. So there's a first more requirement is just to upload our resume over that portal. So whenever we are uploading a resume, definitely there might be certain personal data in our resume. So before accepting that uploading, job recruiter portal should ask your consent. So first of all, the first most requirement is having a proper mechanism. Business has to establish it, how they are going to manage the consent, what should be the management about this, how they are going to receive this consent. This is the one thing. The second thing, as you recently asked, by when this data can be retained. So there's no specific timeline is not mentioned under the act, but I think this will also derive from a different act as well. For example, under the Income Tax Act and the Companies Act, if there's any requirement, okay, by this time, or maybe any court proceedings are going on and the matter is still pending, which has not been disposed of, where the court in. So by that time, you can retain the data. Otherwise, in all other cases, the company should have retention policy by when this data would be retained. And as Shivam also mentioned that once the purpose of collecting that data is achieved, the data should be deleted. So there has to be a clear policy about the retention and the deletion of the data. The other thing is whenever there's any data breach, so I mean, there has to be timeline. As of now, there's no timeline is mentioned under this act. As compared to the EU GDPR, there's a timeline of 72 hours where the data fiduciary has to report this kind of any kind of data breach to the concerned authority and the board. Similarly, in a previous draft, there was the proposed timeline was 72 hours. But in case if we look at the CERT compliances where any breach has to be reported within a 6 hours of the data breach. So there might be inconsistency with the timeline that has to be followed under this act and under the CERT regulations. So this is the one thing. Other than this, a company has to establish a system which can secure the data. As of now, no standard has been defined under the act, like what type of security system should be in place. But in general, before this act, I think company was having, the 27001 ISO certification for the information security purpose. So that may continue, but what exactly standard should a company should follow, which is still not defined. So these are the certain compliance obligation which every company has to follow.
Right. Hopefully, they would be covered in the rules or maybe the regulations in the future course of time.
Yes.
But the like you shared, the company policy on retention of data, that becomes very important, and how it is to be drafted and how it is to be followed, that also becomes very important.
Exactly.
Thank you. Tabriz, which authorities are responsible for the enforcement of Indian data protection laws?
So under the act, there is a new board has been proposed by the name of Data Protection Board of India.
Right.
So before approaching the board, there is a condition precedent that you have to exhaust the redressal mechanism before the data fiduciary itself, which has been regulated through data consent managers. So you have to approach them, exhaust the redressal mechanism. Thereafter, you can go to the Data Protection Board, where you can file your complaint, and entire proceedings will take in form of a digital. There would be proper hearing. You can file submissions, and it would be a quasi-judicial authority. It's in the nature of a regulatory court that we usually have in the form of SEBI and IRDA and other form of regulatory courts, where it would have a power as of a civil court. It can also impose penalty. There's a schedule specific under the act which provides for a penalty for violation of various acts and the omission on the part of the data fiduciary.
And these penalties, sorry to cut you, these penalties are on a very, very higher side.
Oh, yes. Up the maximum goes to 250 crores.
Yes.
So it's very high. And once the decision is made by the board, there's an appellate body is also there. So the existing telecom dispute settlement appellate tribunal has been also given jurisdiction with respect to under this act as well. So if you're not satisfied with the order, you have a right to appeal. You can file an appeal before the TDSAT. That appeal can be filed within a period of 60 days. And that will adjudicate the matters. And the board also have a power to refer the matter for a mediation. So if party wants to mediate and settle it in a form of mediation also, so which is also an alternative method of dispute resolution, they can refer the matter for a mediation for the resolution. So what essentially that we see today is that there's a regulatory authority who is going to watch. So if you commit omission of an act, there could be a sanction by it, there could be an order by it, and there could be enforcement by it. So if you don't follow these rules, if you don't abide by your obligations, then there would be a consequence follows. What essentially there's a difference that one can see is that under the act, all penalties that is collected, it gets credited to the consolidated fund of India. It does not come to the data principals that who have filed a complaint or whose data has been violated. So it's a rather than something in a person, it's a larger right or a larger wrong that you're looking at. There is no right to claim a damages. That perhaps is missing link under it. So if someone wants to claim a right with respect to data, if a ownership of a data is given to a principal, therefore any breach also should accrue to the principal only. That's something, that relationship is missing. So if essentially we see the penalty regime, they have made it a data fiduciary versus state rather than a data fiduciary versus data principal.
Right.
And just to add here, Sandhya, as very rightly put across by Tabriz, and while evaluating the significance of breach and its impact and penalizing a particular fiduciary, the board will consider various aspects as to the nature, gravity, and duration of the breach, and the type and nature of the personal data affected by that particular breach for which a particular fiduciary is being penalized, and whether the offense and the breach was of repetitive nature, whether it has resulted in any gain or avoidance of any law. Like a perfect example of this is which we are seeing most these days, be it on our Instagram, Facebook, or ads in our societies, also gambling, wherein these entities are based out of jurisdiction beyond the control of the government, like Karakau, Armenia, Azerbaijan, where there are no treaties, St. Vincent and Grenadines, and they actually are storing data without knowledge, because we as individuals, just for enjoyment purposes, are getting into these gaming and gambling, and they are processing our data and selling our data, which they are actually compromising with the confidentiality, be it of our credit cards and any other personal information. So this may, once operational, may be able to put a leash on all those such fiduciaries, but yet to test waters, but it will be very good to see this.
Right. So this brings us to the cross-border transfer of personal data, wherein, all of these gaming industries and also, Insta accounts and all other apps which we have been using in our phone. So, Sumit, would you like to share what are the restrictions on cross-border transfer of personal data in the DPDP Act?
Yes. So, see, the present or the erstwhile regime, which was already there in terms of information technology data, the personal data was supposed to be transferred, that, wherein overseas agencies and others were processing the data and taking consents and making you and we under a belief, be it using WhatsApp, are sharing our data and allowing them to process this data, while there are some aspects and regulations and authorities which require localization of data as well, which can be Companies Act as well, Payment and Settlements Act also, guidelines in relation to digital lending also, which is these days on a high rise, and the insurance sector and SEBI, wherein data they are asking you, or the upcoming neobanks where you can open your bank account like this. So they are supposed to localize and store that data, but still there are organizations which are processing your data, they are transferring your data, and they're also storing your data beyond the control of the government. So in order to curb that or use it, wherein they're trying to put everything, be it sensitive, confidential, or not sensitive, under the definition of personal data, by which a particular individual like us or a data principal is or can be identified. So in the Act, the authority has limited as to how this will be done, but in relation to the cross-border, it has required that the receiving entity should guarantee that it will protect this data and give the same level of confidentiality and will comply with the provisions of the Act and the legal agreements are being required to be fulfilled in a manner that if the consent is being given, it will be used for some specific purposes by the said industry and will be stored in the same manner while the data is going cross border. So as per me, when the rules will come, they should also put a control on all these fiduciaries in a manner that they have to localize the data, and the government can any point in time reach out to their compliance officers and make them erase or store and provide the said data where there is a compromise or usage without the consent or not as per the terms of the particular data principle for which he has or she has given consent earlier. So it is yet to see how it will be put into operation, but it is very commendable that this has been put in place. And obviously the definition of personal data has been enlarged as much as possible.
Yes, right. A data protection officer ensures that an organization applies the laws protecting individual personal data. So, Archit, how does the Act mandate to appoint a data protection officer?
Yeah, so first of all, talking about the SPDI rule, which does not mandate, there's no strict requirement of appointing any data protection officer. However, it talks about having a grievance redressal forum, which information should be made public on its website. This act actually has given an obligation on data fiduciary to appoint data protection officer. So, and a significant data fiduciary has to appoint a data protection officer. And like there's a difference between a data fiduciary and the significant data fiduciary, which is a special type of data handler. As of now, what should the precise definition is not given, but the central government may define any data fiduciary or class of data fiduciary as a significant data fiduciary, considering various factors like the volume and sensitivity of data, what they are handling, if any public order is involved, or state security. So these are various function basis, data, significant data fiduciary would be defined, and those would be required to appoint DPO.
Right. A data breach can easily result in identity theft, like we have been discussing and shared by Sumit, when sensitive information is exposed to unauthorized individuals. So, Shivam, can you please tell us what is the regulation for data breach under the DPDP Act?
Yeah, so currently data breaches are regulated by IT Act and its associated rules. The Indian Computer Emergency Response Team functions as a central agency to investigate, to respond, or to receive any data breach notification. However, under the new act, they have designated that data protection board shall be intimated immediately within a reasonable period about the personal data breach. So the period has not been prescribed yet. The central government will prescribe the days within which we have to notify for any data breach immediately to data protection board. Along with the data protection board, the same has to be intimated to data principal. So I'm not aware of why data principal should be notified for any data breach unless and until his security is compromised. So basically, personal data breach has been defined as unauthorized processing of personal data or accidental disclosure, acquisition, or loss of access to personal data that compromise the confidentiality, integrity, or availability of the personal data. So these are certain incident wherein it has to be notified to data protection board and the affected individuals. Then the act outlines certain breach scenarios wherein they have prescribed breach of reasonable security safeguards. Then they have prescribed breach of additional obligations of significant data fiduciaries, violation of voluntary commitment made to the data protection board, general breach of any provision of rules. So they are prescribed under the schedule which goes up to 250 crores by Tabriz. So this is the overview of the data breach under the new act.
Thank you, Shivam. Tabriz, how are cybersecurity and data protection linked? Can you please shed some light on that?
So that is a very important aspect that you have raised. So essentially, if you see data protection, one is the misuse by the data fiduciary. And the inherent linkage that we have with it, that the misuse can also has to be protected not by data fiduciary, by someone else who might try to steal it away. So therefore, in order to safeguard it, it is a responsibility under the act that a data fiduciary has to put measures so far the safeguarding mechanism take place. Therefore, the data fiduciary itself has to put a mechanism which is going to stop a cyber security attacks or some kind of steal of these data. So therefore, with the protection that being granted under the act, the byproduct of it is going to be that there would be a more protection that would happen, and the cyber security front, there would be more security available to our personal data. That is the most one of the inherent nature or the byproduct, maybe you can say, which will come out of the applicability of the act. Essentially, because the penalties are so high, so data fiduciary, in order to protect himself and to protect the breach of data, it will put into place a mechanism that will safeguard it. So that is something very important. And there's another very important provision which is not directly linked to this question I would like to highlight, that the central government also has a sovereign power to stop any transfer of data outside the country. So that is something is very interesting, because ultimately, since the Puttaswamy judgment says the data is a fundamental, privacy is a fundamental right, one hand, and on second hand, to regulate it in a manner, the sovereign power can also be exercised, state power can also be exercised in order to, to restrain the transfer of it from the territory of India. Perhaps maybe for a very strategic reasons of protecting national interest, where the enemy country might misuse those data. So therefore, which is also a very essential provision with respect that the data protection to misuse by an enemy country by way of a cyber security threat or by any other mechanism.
Okay. Shivam, how are the act being in consistency with the other laws which are already there in place?
Yeah, actually, the provisions of the act is not derogatory to any other law, but it is in addition to any other law.
Right.
So in the event of any conflict with the provisions of the DPDP Act and any other law for the time being in force, the provision of this act shall prevail over the other law, since this is a special law. Also, for the current existing legislation, which is SPDI rules and Section 72A of the IT Act, which prescribe for personal data breach, this will be overridden by the provisions of DPDP Act. And then there's a amendment in the RTI Act, wherein disclosure of personal data, there was a provision of exemption wherein personal data can be disclosed by RTI. But now they have amended it to prohibit this ban on disclosure of personal data.
Okay.
This,
so in any case, the provisions of this law will prevail over any other law. So
yes.
There's
a no-obstant clause in this legislation that this act will prevail over any other law.
Right. So adherence to this law becomes very important by everyone, right?
Yes.
Sumit, what are the relevant penalties for violation of the data under the new act? Like Tabriz was sharing very high penalties. Maximum is 250 CR. So what are the relevant penalties for violation?
So the penalties, here it's what they are offering is, or they are putting across in a manner that these penalties are obviously in relation to the what kind of offense has been done and the other acts are obviously providing penalties up to say 5 lakh rupees or a maximum imprisonment. But obviously this has taken to 200 crores and maximum of up to 250 crores. But obviously the data breach should also be proven. And obviously we'll see a humongous amount of litigation and complaints which will be filed against data fiduciaries for, obviously they will take reasonable security safeguards which will be put in place and come forth by the government as to how and what needs to be done. So obviously the monetary fines which have been proposed, like as given under the clause 33 and the schedules of the act, but what will happen as to how it will be assessed and how penalizing will be done in this will be very interesting to see, as to they have given a very high, as in it is penal amounts, but it will be very hard to assess as to how the breach has happened, whether it has actually impacted a particular data principle or not, and to what extent the security safeguards were put in place, and whether, say, there is a situation of hacking and it is beyond the control, or it is not practical for a particular data fiduciary to even stop that. So then how the penalty will be done and whether it was intentional breach or not. So this will be very subjective as of now, but the kind of penalties it has been given at the end, it is starting from 10,000 rupees and goes up to 200 crores and with a maximum limit of 250 crores. Obviously, it is to scare the big boys out there, those who process the data every second, those who are sitting in US and other major jurisdiction, those who are processing our data every second, be it WhatsApp, Facebook, or any other, our banks also, or our overseas bank accounts. And how the data breach will be proven here in India, so it will depend on as to whether what kind of significance it has, whether it was a severe breach, and whether it has actually impacted that individual or not. Like we see a situation wherein, say, I am subject to a cyber fraud and I go to a police station or file a cyber complaint, the person on the other side is yet to even understand as to how I have been affected. They might end up saying that it was your mistake. And it is very hard to even make them believe. And obviously, I am also supposed to, be aware as a data principal, but still it will be very fascinating to see this and how these penalties will be implemented, how data principals will file complaints. So let's see how it goes through, but penalties are commendable, starting from 10,000 goes to 200 and with an upper limit of 250. It is good to catch all those big boys in the market, those who are processing the data. So including the gaming and gambling and betting companies earning big, whom the government is trying to earn as much as possible by putting a 28% GST these days. So let's see how it pans out.
So in case of inconsistency of this act and some other act, for example, in the other act, monetary fine and imprisonment is being mentioned for contravention of a particular section. And here in this act, there are only monetary penalties. There is no imprisonment as a consequence under the act. And the provisions of this act will prevail. So what will happen with the imprisonment part? That would also be an exposure, or that will just go off? How it would be seen and how it would be handled? That is again interesting to know.
But I think under the act, they have provided for it. This is whatever is provided here is in addition to what is already existing. So what penalties are already there, that's what is provided here is going to be in addition to that.
So it is like additional fine.
So no concessions, probably.
Right. Right.
Just to add one more point here, interestingly, under this act, there's a one unique thing as far as penalties are concerned. In case if we look at the other data privacy law, be it a UK GDPR or European GDPR or maybe a Singapore PDP Act, most of the penalties are imposed on data fiduciary or data controller because there's no provision as such where the data subject or data principal have been penalized. But under this act, there's a penalty for the data principal as well, which may be up to 10,000, which is one of the unique thing. So if data principal is not providing the accurate data or fake data, or there was any fake complaint, then that person, that data principal can also be penalized for that. So this is
Right.
one of the unique thing about this act.
Right. But the number is very less.
Yeah, but still there is a certain penalty for them.
Yeah. Right. Great. Shivam, does the data protection law also cover communications, interception, electronic monitoring, and individual surveillance?
Yes, so actually in India, the government intelligence and law enforcement agencies can access data using the authority granted under the IT Act and the Indian Telegraph Act. So this act also permit such processing, but subject to privacy safeguard. So particularly when carried out by the instrumentality of a state. So whenever the state government or central government or any law enforcement agency is intercepting this data in the interest of Indian sovereignty, security, good relation with foreign country, maintaining public order or preventing encouragement of preventing any offenses of criminal offenses. So in these cases, they can intercept the data and this act will not apply in such case. Also, the government is empowered to exempt any specific data handling entities from adhering to any part of the act. So by an official notification. So these are the provisions which indicate that the government holds substantial authority under the DPDP Act to release itself from the specific obligation to the data protection.
Okay, great. Thank you so much. So this brings us to the end of this session. And before we end the session, we would like to take a few questions. There are many actually. And I'm sure that these were placed during the session. A lot of them would have already been answered by the speakers. If a director of the company gives his or her personal information to the company, whether in this case the relationship of data fiduciary and data principal is established, would anyone of you would like to take up?
So I want to answer this query. So first of all, the director is giving his personal information to the company. Then first it has to be personal data in digitized form. So whenever the director is giving that as a digitized form to the company, it has to be used for that specific company is taking his data, except subject to certain restrictions. Suppose if MCA asks the company to give the details of directors or files with MCA portal, so in that case they have to disclose it to MCA, but they don't have to disclose to any other entity or person. Only the director data can be used only for the specified purpose of his appointment. And also there's an exemption as mentioned by Sumit in case of employment agreement. The data can be used after the termination of employment in considering the confidentiality and non-compete clause. So in such case, if director is an executive director working whole time in the company, so there would be an employment agreement with the director. In such case, such data can be used for protection of confidentiality and non-solicitation also.
Okay. Has the act come into force, or do we have time for compliance till the rules are formulated?
The law itself is in force now, but the manner in which compliance has to happen, there will be specific rules that will be notified.
Actually, there would be a transition period which government will notify, during which everyone has to adopt this law. So there might be a phases wise. that these sections will be enforced in one phase and this section will be enforced in second phase.
Right. Is this act limited to only digital activities? Can a printed communication be sent by post or courier?
So this is applicable on only a digital personal data. So in case if you are sending something in a physical manner as a printout, but later on if that physical copies has been converted into any a scanned copy or any digitized form, then this act would be applicable.
Right. Will there be any penalty for breach? This we have already discussed. If so, what will be the cost? Whether director be prosecuted? If director has done the breach, then yes, the director will also be subject to the consequences, which includes penalties. A case where the entire database, the data owner's website is compromised by the registrar of domains. Say the domain name is bundled by registrar and therefore all the data got compromised. Will this new law cover this type of case?
Currently, the data principal is responsible for the acts of even the data. Data fiduciary is responsible for all the act of even data processor. So even if you engage data processor, that should act on behalf of data fiduciary only. So data fiduciary will be responsible for any such error. Though this is this scenario has not been captured, which they have mentioned in the query, but it has to see it has to be seen what could be done in that case.
Right. Will use of cookies or tracking IP addresses also be considered as personal data?
So actually, personal data has been defined as a data which can be related to any individual. So if there's an anonymous data, then it will not be covered under the personal data. But if you can identify some individual by virtue of the data, then that would be covered. So I think cookies data would not be covered, since we cannot identify the individual who is who is giving the data.
But if say in a scenario, by clicking that particular data and you have filled your information and then it asks for cookies so that it can be identified, only then it will be part of personal data. But if you have provided your information earlier or some app is providing that information and then say, because always say we use Google Chrome and you've already signed in, and through that website it is opening and then asking for cookies. So then that particular individual is identified either by that sign in or by that particular IP address, say your office, your home Wi-Fi. That individual should be identifiable or that person data principal. Then it may fall under the data as in the personal data.
Okay. Then next we have accidental breach is also covered.
Accidental breach is also covered in the personal breach.
Yes.
As I read the definition of personal data breach. So accidental, there has to be the confidentiality or integrity of that personal data should be hampered in that accidental scenario.
There has to be some
Because-
consequence of the breach.
Yeah, because processing of data per se is covering everything, be it compromise of the confidentiality or that data in any manner whatsoever.
And the safeguarding responsibility remains with the data fiduciary only.
There is difference between Data and IT Protection Act. I think the participant would like to know if there is any difference between Data and IT Protection Act.
So the provision which was section 43A, which provided for data protection, stands repealed by virtue of this act. There is a specific provision under the act by which that 43A comes to repeat.
Right. What are an employer's obligations towards employees' personal data? Please give example for when employer needs to take consent and when employer is exempted from taking consent.
So particularly in a practicality, all the employer, whenever they are seeking any personal information of the data principal or maybe particularly employee, they have to give them itemized notice. Itemized means they have to give all the particulars, okay, what all data they are seeking from the employee. So once there's a consent from the data principal, then that data can be operated by the employer. Then that has to be secured in a safe way. Then the retention and deletion policy will have a role to play. So these are the obligation at the employer side. But generally, generally employer has to process the personal information of employee for various reasons, particularly in case they have hired any third party vendor who is processing a payroll services and who is processing a salary. So just to process a salary, employer may need your bank account, PAN number, and other details as well. So once you've consented that, they may process that. However, they have to delete the data once the purpose is achieved or once the employee has left the that company.
Thank you, Ashik. Due to paucity of time, we will now just take the last question, and this is the latest one. How are social media posts covered under this act, as they are info voluntarily put out, and the act in its applicability section specifically states that such data won't be covered under the act?
Actually, Act does not cover such data which has been put in public. So it excludes from the personal data. It excludes such data which has been disclosed to public. So it won't be covered under this act.
In fact,
Only if there's a private account.
in fact, they have given example of blog also in the act itself. If someone has written the blog himself, then that will not get covered into it.
So I thank all the speakers and all the participants to be with us in this session. It was such an insightful session. A lot of new provisions which have come into the law, and you all have shared it so quickly. So thank you everyone. Thank you Shivam, Sumit, Tabrez, and Ashik. Thank you so much for being with us.
Thank you very
Thank you.
much. Thank you everyone
Thank
for
you for
attending.
Thank you.
Thank you, Sandhya. Thank you.
Thank you. Thank you for joining us. Thank you.